Donald Trump has just openly defied a direct Supreme Court order, and Congressman Shri Thanedar has answered by dropping the ultimate constitutional hammer, articles of impeachment. Welcome back to the channel. You are currently watching Daniel Cave, and today we are meticulously breaking down an unprecedented, sprawling crisis that is entirely unlike anything we have ever witnessed in the expansive, complex history of the American Republic. Let us commence by carefully tracing the dramatic origins of this monumental event, beginning directly with the initial, shocking wave of breaking news that ultimately set this entire chaotic historical sequence into rapid motion. During the highly anticipated 5:30 evening television broadcast on Wednesday, April 30th, veteran anchors Simon Shate and Glenda Lewis solemnly welcomed their viewers to a rapidly developing story that has since triggered massive, undeniable shockwaves and provoked intensely strong, deeply emotional responses from political figures and citizens situated on both sides of the partisan divide. During this monumental broadcast, dedicated investigative reporter Mike Duffy presented audiences across the nation with an exclusive, deeply revealing one-on-one sit-down interview featuring Democratic Congressman Shri Thanedar, the elected official currently representing Michigan's vibrant 13th House District. Exactly as the current Trump administration was officially marking its highly scrutinized, turbulent first 100 days in executive power, Congressman Thanedar arrived at the incredibly heavy, historic decision to formally bring forward 7 distinct, meticulously drafted articles of impeachment targeted directly against the sitting president of the United States. The subsequent political reaction emanating from the White House and its supporters was not merely swift, it was utterly instantaneous and undeniably explosive in its sheer rhetorical ferocity. If you happened to be watching the raucous, densely packed political rally held in the city of Warren last night, you personally witnessed President Trump take to the brightly lit stage to directly and aggressively address these newly minted, highly controversial articles of impeachment in real time. However, instead of thoughtfully or carefully engaging with the severe legal substance or the profound constitutional gravity of the charges leveled against him, Trump instinctively resorted to his familiar, aggressively rhetorical tactics. From the podium, he viciously mocked the congressman, publicly branding him a lunatic and loudly labeling him crazy, while simultaneously and bizarrely claiming to his roaring audience that he had never even heard of the man, seemingly confusing him entirely with another political figure from Michigan, John James. When officially asked by the press to comment on this hostile, highly personalized reaction, Congressman Thanedar remained incredibly measured, remarkably steadfast, and perfectly composed, clearly stating for the public record that he absolutely refuses to allow himself to get dragged down into the muddy waters of petty, unproductive name-calling. Instead, the congressman eloquently and firmly articulated that he is simply executing the core, fundamental duties of his elected job and rigorously fulfilling the sacred, binding oath of office he solemnly took to fiercely protect and resolutely defend the United States Constitution, an identical, profound oath that Donald Trump himself also swore to uphold before the entire nation. Thanedar explicitly pointed out that over the turbulent course of the last 100 days, the president has aggressively issued sweeping executive orders that directly and flagrantly violate the foundational text of the Constitution, adding that the president's most recent defiant actions left the congressman with absolutely no other viable democratic choice but to actively pursue the ultimate remedy of impeachment. To truly and comprehensively grasp the sheer magnitude of what is currently unfolding before our very eyes, we must carefully look at the primary legal catalyst, a definitive, unanimous 9-0 Supreme Court ruling that was handed down just 2 short weeks ago. This monumental, history-making ruling did not just suddenly appear out of thin air in a judicial vacuum. Rather, it was the ultimate, inescapable culmination of agonizing months of exhausting, fiercely sustained, and highly complex multi-level litigation regarding the Trump administration's incredibly aggressive and highly controversial immigration enforcement policies. Numerous multiple lower federal courts across the country had already meticulously examined these harsh administrative practices and repeatedly concluded, with a clearly growing sense of profound judicial frustration, that the president was blatantly, undeniably violating established federal law. The administration, according to these damning lower court rulings, had systematically engaged in sweeping, indiscriminate mass deportations without ever providing the legally required fundamental hearings. They had arbitrarily detained vulnerable individuals for extended periods without offering any of the established procedural protections. And they had callously denied vital asylum claims without conducting the rigorous due process evaluations that federal law so rigorously and unconditionally demands. President Trump fiercely fought these judicial rulings tooth and nail at every single conceivable turn of the legal process. He aggressively deployed the full, massive, and virtually unlimited legal resources of the sprawling executive branch to exhaust every conceivable procedural avenue, strategically utilizing every available delay mechanism his formidable legal team could possibly construct in a desperate, calculated bid to simply run out the clock. He stubbornly and relentlessly appealed every single adverse ruling up the intricate judicial chain until the consolidated cases finally reached the majestic marble steps of the highest court in the land, seeking what he undoubtedly believed would be a definitive, final, and unappealable resolution in his political favor. However, when the Supreme Court finally ruled on the matter, the justices did not use any narrow, heavily hedged, or ambiguous language that clever, high-priced lawyers could creatively manipulate to claim some form of technical, loophole compliance. The court ruled decisively and powerfully against the president with unmistakable, crystal clarity, affirming precisely what every single lower court judge had previously found. His draconian immigration policies grossly exceeded his legal statutory authority and unequivocally, fundamentally violated the law of the land. The court immediately issued a direct, legally binding order compelling the president to permanently stop these unlawful enforcement actions, firmly commanding him to immediately reinstate the crucial legal protections he had deliberately and systematically dismantled, and demanding that he take affirmative, verifiable, and urgent steps to locate and return the specific individuals who had been wrongfully deported in direct, flagrant violation of active, ongoing court orders. What happened immediately next is genuinely staggering to comprehend as a citizen of a constitutional democracy. President Trump openly, highly publicly, and without demonstrating any apparent hesitation or second thought whatsoever, boldly declared to the entire watching nation that he absolutely will not comply with the mandate. He stated plainly to the press corps, and entirely without a shred of apology, that the judicial branch simply lacks the necessary constitutional authority to constrain his presidential actions or dictate his executive policies. He essentially, incredibly, told the United States Supreme Court, the very same esteemed institution that he personally helped aggressively shape with his own highly publicized lifetime judicial appointments, that its legally binding orders simply do not apply to him in any way, shape, or form, and that its immense historical authority effectively stops directly at his doorstep. To vividly illustrate the devastating human cost of this legal standoff, Congressman Thanedar specifically highlighted the tragic, heartbreaking case of Mr. Garcia, a man originally from El Salvador who was illegally, callously deported without receiving even a minimal shred of the due process he was guaranteed. President Trump has actually explicitly admitted on the public record that he possesses the logistical and legal ability to easily bring Mr. Garcia back to American soil, but stated defiantly, aggressively, and without a hint of remorse that he simply will not do it. For Congressman Thanedar, a diligent representative who was already actively fielding intense, furious demands from highly concerned constituents at packed local town halls, desperately asking why the president wasn't being forcefully held accountable for his destructive actions. This blatant public defiance of a direct Supreme Court order instantly became the final, undeniable straw that broke the camel's back. The immense historical weight of this unprecedented, terrifying moment simply cannot be overstated or exaggerated in any context. Trump's shocking, deliberate response represents a dark phenomenon that has never once occurred in the entire centuries-long history of the American Republic. Absolutely no president in history has ever openly, proudly refused to comply with a direct, unambiguous Supreme Court ruling directed specifically at their administration. While past presidents throughout history have certainly frequently criticized judicial decisions they fiercely disagreed with, expressed deep public frustration with institutional constraints placed on their executive authority, and actively sought out new legislative remedies to successfully overturn rulings they deeply despised. Not one single president across the entire vast span of American constitutional governance has ever looked directly at a Supreme Court order and boldly said, "I will not do what you are telling me to do." The vital, irreplaceable democratic norm of voluntary compliance has always been so deeply, intricately embedded within our unwritten Constitution that it was simply universally assumed to be an unbreakable rule of political physics. It never even needed to be formally codified into written law because no president had ever dared to actually force the chaotic hypothetical question into stark, undeniable reality. By intentionally and maliciously crossing the sacred line from mere rhetorical criticism to open, unrepentant, and flagrant defiance, Trump has single-handedly transformed a tense legal dispute over immigration into a catastrophic constitutional crisis of the absolute highest imaginable order. As a direct, immediate result of this unprecedented and shocking executive defiance, the heavy, complex constitutional machinery is now aggressively and loudly grinding into motion over on Capitol Hill. House Resolution 353 has been officially and formally introduced into the chamber, successfully placing the grave articles of impeachment for high crimes and misdemeanors officially on paper and permanently onto the legislative record for all of history to scrutinize. The momentous resolution has been promptly and efficiently referred to the powerful House Judiciary Committee, which will shortly commence the rigorous, painstaking process of deep investigation, carefully examining all available documentary evidence, gathering crucial sworn testimony from relevant officials, and methodically building the ultimate constitutional case, utilizing the full, formidable institutional weight of the legislative branch of government. This is not a hypothetical scenario or a mere political threat. This is an active, rapidly fast-moving impeachment proceeding currently journeying its way through the very heart of the United States government right now as we speak. However, the stark political reality surrounding this dramatic legislative maneuver remains deeply, bitterly divided along strict, predictable partisan lines. Republican State Senator Jim Runstead, for instance, views the unfolding chaotic situation entirely differently than his Democratic counterparts. When explicitly asked by reporters about Trump's bombastic reaction at the recent campaign rally, Runstead quickly characterized the entire impeachment effort as completely comical, loudly accusing the Democrats of lazily and desperately replaying the exact same exhausted political playbook from Trump's previous 4 tumultuous years in office, heavily referencing the controversial past Russian collusion investigations and previous, highly contested impeachments. Runstead confidently and publicly theorized that because Democratic poll numbers are currently imploding across the board, Congressman Thanedar is selfishly using this extreme, drastic measure simply as pure political gold to successfully stave off his own fierce primary opponents back in his home district. Adding further academic weight to this deeply skeptical perspective, Dave Dulio, an esteemed professor of political science, actively teaching at Oakland University, publicly weighed in on the actual political viability and future of these newly introduced articles. Professor Dulio firmly suggested that this entire media spectacle is ultimately much ado about nothing in strictly practical, legislative terms, confidently asserting that the articles are essentially dead on arrival because the necessary votes simply do not exist to successfully impeach Donald Trump while loyal. Steadfast Republicans continue to hold a firm, commanding majority in the House of Representatives. Dulio passionately believes that Thanedar is primarily effectively reflecting the raw, unbridled anger of the frustrated Democratic base, strategically giving them a highly vocal representative who is visibly willing to stand up and forcefully fight the administration on their behalf, regardless of the ultimate legislative outcome. Yet, despite the thick, suffocating clouds of political skepticism hovering over Washington, D.C., the fundamental structural facts of this incredible third impeachment effort make it entirely and fundamentally different from the previous two historical attempts. During his chaotic, headline-dominating first term, the House famously impeached Trump twice, the first time for a complex abuse of power and obstruction directly related to pressuring the sovereign nation of Ukraine, and the second time for the grave, unprecedented charge of incitement, of insurrection, immediately following the tragic, violent attack on the Capitol building. In both of those deeply historic, heavily scrutinized cases, the Senate ultimately failed to reach the incredibly high, demanding two-thirds threshold required for a successful conviction, thereby allowing Trump to loudly claim total vindication and easily dismiss the exhaustive proceedings as nothing more than politically motivated persecution orchestrated by his sworn enemies. But it is absolutely vital to remember that those previous, highly polarized impeachments involved fiercely contested facts, deeply varied witness testimonies, and incredibly heavily disputed legal interpretations of chaotic events. Politicians and pundits could, and endlessly did, argue over whether the infamous Ukraine phone call was truly, legally a corrupt quid pro quo, or whether the passionate, fiery January 6th speech actually met the incredibly strict, precise legal definition of criminal incitement. Those lingering, complex ambiguities provided massive, invaluable political cover for any Republicans who desperately wished to defend the president's controversial actions to their constituents. This time, however, the situation is completely and utterly different. There is absolutely no ambiguity to be found anywhere in this narrative. There is no alternative, competing version of events to debate on television, no murky factual dispute left to endlessly litigate in the press, and absolutely no gray area requiring careful, nuanced legal analysis. The undeniable, stark reality is that the Supreme Court legally issued a lawful, crystal-clear, binding order, and the president publicly, shamelessly refused to obey it. That represents the entire comprehensive case, completely stripped of all exhausting legal complexity and effectively reduced to a simple, undeniable binary proposition that any average American citizen can instantly and perfectly understand without a law degree. The sheer, unmistakable clarity of this blatant, broadcasted violation makes defending the president's behavior extraordinarily difficult, a stark reality that could very potentially alter the entire political calculus in Washington and ultimately unlock crucial Republican votes that were entirely, hopelessly unavailable to Democrats in the past. Furthermore, the underlying, devastating human tragedy woven deeply throughout this epic, high-stakes legal battle is equally, if not far more, profound. The desperate, marginalized individuals tragically caught directly in the chaotic crossfire of Trump's defiantly executed, cruel policies are actual living human beings who genuinely possessed completely valid, documented legal claims to legally remain safely within the United States. These were deeply vulnerable, terrified asylum seekers who genuinely, rightfully feared severe, life-threatening persecution or outright death in their unstable native home countries. Instead of properly receiving the fair, impartial legal hearings to which they were completely legally entitled under existing federal law, the administration mercilessly rushed them through a broken, overwhelmed system, completely violating their fundamental, unalienable due process rights and callously deported them right back to the exact same lethal dangers they were so desperately attempting to escape in the first place. The courts definitively and morally ruled that the federal government possessed a strict, unyielding, and binding obligation to actively locate these marginalized individuals and immediately bring them back for proper legal hearings. However, successfully executing that monumental logistical obligation is incredibly difficult. Terrified people, deported back to highly dangerous, cartel-run nations often go deep into hiding merely to survive the week, and tragically, some may have already been brutally imprisoned or even killed immediately upon their forced return. Trump's absolute, stubborn, and highly publicized refusal to even remotely attempt basic compliance with the court's humanitarian order demonstrates a profoundly chilling, heartless contempt for these suffering individuals and exponentially compounds the potentially catastrophic, irreversible, and deadly harm that has already been inflicted upon them and their shattered families. Trump, for his part, fiercely defends his unprecedented, historic defiance by loudly arguing that immigration enforcement naturally falls completely and exclusively under the inherent constitutional authority and broad prosecutorial discretion of the executive branch, aggressively claiming that unelected courts absolutely cannot dictate how he personally chooses to exercise that immense sweeping power. While prosecutorial discretion is undeniably a very real, established legal concept taught in every law school, it is absolutely not a boundless, unchecked blank check designed to allow an executive to entirely ignore the established law of the land. It absolutely, unequivocally does not grant any sitting president the dictatorial, absolute, king-like authority to completely violate established statutes passed by the United States Congress, or to arrogantly disregard legally binding court orders issued by the highest judiciary in the nation. This alarming, highly unstable dynamic brings us directly to the absolute core enforcement problem currently facing our beleaguered, tested judiciary. The frightening reality is that courts can boldly issue all the rulings, injunctions, and paper orders they possibly want, but they possess absolutely no independent physical mechanism to actually force or compel obedience from a rogue executive. They cannot magically deploy armed military forces or federal agents to forcibly seize control of the sprawling executive branch, nor can they physically, forcefully stay a defiant president's hand. Their immense institutional power and societal relevance rely entirely, completely on the shared, unspoken, voluntary understanding that the bedrock rule of law strictly requires mutual respect and submission from all branches of government. When a sitting president intentionally and proudly breaks that sacred foundational trust, arrogantly asserting that his executive power is limited only by his own personal, subjective judgment and political whims, the entire situation becomes dangerously, incredibly incompatible with the basic, fundamental tenets of constitutional governance that have sustained this nation for centuries. In this exact constitutional nightmare scenario, the brilliant framers of the Constitution provided the nation with only one viable, powerful, and ultimate remedy. Under the strict, clear guidelines of Article 2, Section 4, the president can absolutely be forcibly removed from the highest office upon successful impeachment for committing high crimes and misdemeanors. While legal scholars and historians may endlessly debate the precise historical boundaries and definitions of that specific phrase, there exists a massive, broad consensus that it undeniably encompasses any serious, systemic, and intentional abuses of power that directly threaten to upend the established constitutional order and the delicate balance of powers. Congress is absolutely not meant to be a quiet, passive observer in this dangerous dynamic. The brilliant founders explicitly, intentionally designated the legislative branch as the ultimate, supreme check on unchecked executive overreach, meticulously designing it as the vital democratic circuit breaker meant to activate the very moment a president begins to behave as an unconstrained, rogue monarch rather than a respectful, co-equal branch of a democratic government. The impending stakes of the coming days, weeks, and months are truly monumental and deeply historic. Every single day that Donald Trump aggressively persists in his blatant public defiance is yet another dark day that the sacred separation of powers is dangerously, profoundly weakened and eroded. If the diligent House committee formally recommends impeachment after their investigation, it will require only a simple, highly achievable majority to successfully pass through the House of Representatives. But if Congress ultimately cowardly declines to impeach out of partisan fear, or if the deeply divided Senate once again fails to secure the necessary conviction, the horrifying indelible precedent that will be established will fundamentally and forever alter the very nature and future of the American government. Future presidents from across the political spectrum will inevitably observe that the ultimate, final check on blatant executive lawlessness has completely failed, effectively turning binding judicial rulings into mere polite suggestions and rapidly inevitably pushing the United States dangerously closer to the dark, inescapable precipice of authoritarianism. Conversely, if they courageously choose to hold him strictly and legally accountable, it will powerfully reaffirm the beautiful, enduring democratic principle that absolutely no person, not even the incredibly powerful President of the United States, stands above the rigid confines of the law. The elected members of Congress are right now, at this very moment, facing the single most consequential, defining votes of their entire political careers and lifetimes, essentially forced to finally choose between blind, partisan loyalty to a single, polarizing politician and unwavering, patriotic loyalty to the United States Constitution itself. Make no mistake, the eyes of history are currently watching these dramatic events unfold very closely, and the only remaining question that truly matters right now is whether enough brave members will rise to meet the immense gravity of the occasion and definitively prove to the entire world that our Constitution remains a living, highly functional, and robust framework of accountability precisely when we desperately need it the absolute most. You have been watching Daniel Cave. Please be sure to drop your thoughts, passionate opinions, and unique insights down in the active comments section below, and absolutely do not forget to hit that subscribe button to help us rapidly hit our ambitious goal of 100,000 subscribers as we continue to relentlessly track, analyze, and break down this incredibly explosive, thoroughly historic development as it happens.